Impact of Influence, the Murdaugh family murders. This is the unfolding story of a powerful South Carolina family, the mysterious deaths they are linked to, and our quest to bring you the truth. Hello, friend. Little bonus episode this week. I am Matt Harris. Seton Tucker is here. We're going to talk to an attorney who's representing a few of the jurors that are involved in this defense motion. Alex Murdaugh's defense team had the presser this week about potential jury tampering by the clerk of courts, Becky Hill of Colleton County. And we, in our last episode, gave you excerpts of the interview we had with her just a few months prior, and all the details and more are leaking out, and we'll have those as they happen. And you can go to Impact of Influence on Facebook. Let's bring in a friend of the show. He's been on a few times, a good guy. He's representing a few of the jurors. He is Joe McCullouch, a seasoned litigator and former prosecutor, over 40 years of experience. So, Joe, you represented one of the jurors right after the trial because that juror was getting a lot of harassment, for lack of a better term, from media, correct? That's where this first started, your connection.
Correct. My involvement with jurors began with the request from one of them to see if I couldn't intercede and prevent the invasions of privacy, people crawling over her fence and banging on the doors.
Mm-hmm. And then how did that progress? When did you get news that there was going to be multiple jurors and you were going to represent more than just that original juror?
Well, I don't want to get too much into the issues of representation, other than to say that at a point, as there began to be murmurings, I suppose you could say, about the process of deliberation. And obviously at the time that the jury returned a verdict with such speed, it surprised many of us and had a lot of the commentators and trial lawyers scratching their heads about how a jury, after 6 weeks of evidence, could reach a verdict quite that quickly. But in any event, I began to get phone calls from other jurors, and so now currently I represent two. I've spoken with several others, and I understand this morning that Mr. Griffin and Mr. Harpootlian are urging jurors to find a lawyer, and I think that's wise. These are deep waters, and they're concerning allegations, and like the old saying, you can't be a little bit pregnant. You can't give somebody a little bit of a fair trial.
Yeah.
And that's what this court's mandate is by reason of this motion, and the law has a high bar for intruding into a jury verdict, because we give great respect and deference to juries and their deliberations and their ultimate decisions. But there is plenty of case law in a United States Supreme Court case that observes that once that high bar is met and exceeded by whatever the prosecution, whatever the defense presentation is, whatever the evidence in support of their motion is, that the presumption switches around, and it becomes the burden of the state to show that it was a fair process. We're not at that point, but we'll see if it gets there. But I think at this point, this is an inquiry. The people that served on this jury can expect to be questioned by some entity, agency. I don't at this point know whether that will be SLED, the FBI, or whoever, but it is going to begin to be a new search for the truth of what happened behind those closed doors.
So SLED or some law enforcement agency will investigate, and then it will be determined if they'll have this additional hearing? Is that how it works?
Well, Seton, I think that we're in kind of new waters to some extent. This is not the first time that that allegations have been made by either the prosecution or typically the allegations of jury tampering are made by the prosecution. John Gotti's a lovely example of that.
Oh, yeah.
Clarence Darrow actually was tried for jury tampering, that famous fiery defense lawyer.
Yeah.
So, I mean, there's a history, but this kind of an allegation coming from this side of the equation is a little bit different. And so I think at this point, the motion that I read yesterday, filed by the defense, calls upon the Court of Appeals, which is where their appeal of the conviction has been filed. It asks the court to, I think, remand the matter to the trial court. It also, I noticed there was also filed at the same time, or maybe not filed, but at least I was provided a request to the U.S. Attorney's Office to initiate a civil rights investigation. So that's why I say I'm not sure who the investigating body, the inquiring body will be.
Yeah, because it seemed like they had a problem with SLED investigating it because SLED did the original investigation, so they would be kind of investigating themselves.
And it was, like Dick said, a vested interest in having the sentence stand because that's what they wanted. That was their goal.
Well,
so that makes sense.
Yeah, I think the allegation made yesterday, I guess, by Dick and Jim in their press conference, if not in the documents themselves, suggests that SLED, as the prosecuting agency, would have a vested interest, logically, in protecting the verdict. So I think that's a legitimate concern. I'm sure that SLED will announce that they can be quite objective about it, and perhaps they can. But I think that the defense would not be doing their job if they did not try to propose the problem, the potential problem. I mean, we talk a lot in the law about the appearance of impropriety. So does it appear to be improper for an agency with a vested interest to be investigating the process? Good question. That the courts will have to decide.
Joe, do you have any opinion on what the juror who dismissed says in her affidavit? She says she was delivering a refrigerator to two people who were renting from her, and that they claimed that she talked about the trial during this
little meeting or drop off.
Right.
That they go to work at Domino's, or one of them does, tells a coworker that Egg Lady juror was yapping about the case. The coworker reports it to SLED. SLED shows up at the renter's house at like what time?
10 o'clock. 10 o'clock. And they're asked to go back to the court the next day. They arrive at 9 a.m. And at 6 p.m., they're finally presented with these affidavits.
Now, the affidavits they got from the night before, I guess we missed that part. So SLED goes to their house after 9, pulls them out of the house, puts them in the car, puts them in the patrol car, puts the dash cam on. They record this conversation. They turn it into an affidavit. After they're sitting 7 hours or 9 hours the next day at the courthouse, and they say they signed them and they weren't really aware of what was on them. They tell Egg Lady, we didn't say that. This is all a bunch of nonsense.
Yeah, because I guess they were informed that the affidavits were taken straight from the dash cam video. So SLED advised them that the affidavits were taken straight from the dash cam videos.
And they say that that's not true. So anyway, all that to say, Joe, is what do you feel about SLED investigating the way they did this juror?
Well, my role here, Seton, is not to be an investigator. It is, frankly, to be an advisor to my clients, these jurors that I represent, and their sounding board, but also their protector.
Yeah.
And so I know what I've read, as you actually probably have had access to a little bit more information than y'all have, but I mean, the fact is that SLED evidently did go out and conduct some type of investigation that preceded the juror's removal on the day that the case was to go to the jury. Those circumstances, I really obviously was not involved at the time. At that point in this process, I was the guy sitting on the fifth row, watching the trial with everyone. And so I can't give you much enlightenment on that because I wasn't involved in that. And again, these affidavits provided by jurors are sworn affidavits in two instances, and I think a reiteration of information provided in a third affidavit, as I recall, from a person who had not ultimately signed an affidavit. But I mean, those things are part of the fabric of this case or this inquiry, and they're going to be part of the question mark about the fairness of the process, because the fairness of the process will involve not only what happened backstage in terms of these allegations, but it may actually and ultimately get to the question of whether that juror should have been removed, whether the court acted on information that was incomplete or inaccurate or whatever. But of course, we will never now know how that juror would have voted, and we will never know what effect her removal had on the ultimate decision in this case. But that's what this inquiry is about. Was it a fair process?
All right, Joe. Appreciate it, man. We'll talk soon.
Yep. Bye-bye.
Later, Joe. All right. Please rate, review, share the episode, share the podcast. We are always so grateful anytime we get a listen. We love feedback, good, bad, or indifferent. So send it our way on the Facebook page, Impact of Influence. We really super appreciate you listening to us. We're grateful, and we'll talk soon, friend.